So the purpose of this afternoon is to provide all of you with some general updates, some trends that we have been seeing in our virtual courtrooms, as well as some updates on our divisions, our divisional procedures, and I guess give you some tips that I think will help move your cases, both complicated and uncomplicated, forward during this time. So I'll start with my division. Luckily, we've been able to operate above 75% capacity on mostly uncomplicated matters. Most of the hearings I've been doing have been enforcement hearings at this point. We've not done a lot of complex cases that require guideline calculations or a lot of documentary evidence, which I think is something that you've heard from the bench pretty much up and down at this point, that we don't necessarily have the technical capabilities to do so or procedures set in place. So I've been doing mostly contempts, driver's licenses, issues like that. We have been able to schedule status conferences on a lot of other hearings, and that's something I'll be doing going forward to see where we can fit everybody in. As far as doing more complex cases, that's something we're going to start looking into and possibly doing trial runs. And that's something I will touch on towards the end of my little agenda that I have. But I think it may answer a lot of questions. So I'm going to let everyone else kind of give an update on their divisions, and then we'll go down a list of kind of some family law updates, some other things, including the CARES Act. I know a lot of you may have questions about that, and then some tips. So either one of you want to go first?
Sure. So in my division, we've been conducting hearings via Zoom. I'm giving hearings a little bit more time than I normally would if we were in the regular courtroom, because things do take a little longer, everyone logging on. Initially, someone can't hear or we can't see someone. So I am making hearing time a little bit longer and being a little bit more patient with everyone, and I think everyone's doing that. Our Zoom instructions are on the 17th Circuit website. Donna, my assistant, has been calling people to make sure that they have the instructions. We have been conducting trials with evidence, and it's been going well so far. What else about my division? I wanted to give everyone the divisional email who is on, just in case you have questions and for some reason you can't get a hold of Donna. We are trying to call people back as quickly as we can and to get in contact with people, but for some reason we can't. We're going to go ahead and put our email up to make sure that everyone has our email on the website. But I think that's it for our division.
Okay.
Hi, everyone. We're from division, well, Nadej and I are from division 91, and I echo everything that both Matt and Hearing Officer Tannenbaum and General Magistrate Matalon have said. The only thing was I was kind of taken aback. I had a hearing all day, and someone asked me how it was at the courthouse. We're all at our homes. That's and we're doing this from home, so we don't have everything that we normally have, nor do we have the paperwork. Just if you sent paperwork in and you sent a notebook in, we don't have access to that unless you put it, unless you can get with CMS and put that into the documents. And of course, it doesn't have to just be evidence. It can be pieces of paper. We just, whether we see it or not, we can make decisions about that at the hearing. It is very hard to just hold something up to the camera, including driver's licenses, and let me see when the issuance date is. So if you can just make a copy of something or have them make a copy and then download it or upload it actually to CMS in a document, then that would probably help. The only other thing is when you are submitting things to us, and I believe that that's if you are responsible for doing the report and the order, or the recommended order and the order ratifying the same, it has to be in a Word document. And if you want us to attach the guidelines that you have done You need to convert them into a Word document. I had someone that was able to do that. And when I put it all together so that I could put it into one document and upload it to CMS and sign it electronically, there were some weird margins. So if you can just take out all of the, take out all of the weird margins and the things that, you know, and just have it as a child support guideline, I was able to do that. Otherwise, in my division, I am referencing the filing number and the date as if the child support guidelines were actually attached to the report that I'm doing, because there is a second DCA case that says if we don't make findings on the gross and net incomes and attach the final judgment, and attach the guidelines, then it is reversible error. So in order to do that, that's how I'm doing that. Thank you.
Okay, and that's something I think we're going to expand upon a little bit later, the electronic filings and the importance of not using snail mail if possible, because we may not see your documents. Some updates I wanted to give specific to some of my cases, first being the issue of driver's license suspensions. As far as I know, and this has not been 100% clarified to me, if the Department of Revenue is seeking to suspend the driver's license, DMV is still processing those suspensions. So your clients may still get letters in the mail indicating that their licenses may be suspended. Now, I know there was a tolling order on driver's license expirations, but I do not think that applies to suspensions. I know if you were on the bench and bar meeting, I believe on Monday with Judge Tuter, he indicated that he I believe thought that the driver's licenses weren't thought to be suspended, but I think, to clarify, that only applies when the clerk is seeking to suspend the driver's license. So I do want to give you fair warning that those DOR suspensions, those may still be going through. So out of abundance of caution, I would suggest probably filing those motions timely if your clients are getting those notices. Second and related issue, writs of arrest for non-payment of child support or other civil contempts. As far as I know, those are not being enforced, nor are they necessarily being processed right now. So if you're seeking a writ of arrest, I don't think those are going through. I don't think those are being processed. I also don't think BSO is going to arrest them right now. They don't want to crowd the jail out of an abundance of caution. To prevent an outbreak in the jail. I know there have been some reported news reports about some positive diagnoses in the jail of COVID-19. A third issue specific to some of, actually all of our cases, would be the CARES Act and how it is affecting those who owe child support. I know there was some confusion in the beginning when the act was first passed, but it has been clarified that if the recipient of the economic impact payment, which is up to $1,200, owes child support, that money will be forwarded to the payee first up to the amount that is owed. So if they owe over, let's say they're getting $1,200 and they owe over $1,200, all that money is being forwarded by the IRS to the payee. So they should not expect to see any of that money. An emerging trend that I've been seeing as the crisis kind of wears on has been motions for temporary abatements or modifications of child support. And GMs Matalon and Szorosy, I don't know if you've been seeing that as well. One problem I'm seeing is a lot of these actions are, well, the problem is twofold. One is they're being filed on motion, which to my knowledge, I don't know. And again, this is not a blanket rule. I really want to put that out there. It's not a blanket rule, and it may or may not apply to your cases. But I don't know of any authority that allows me to grant a temporary abatement. Well, no, not a temporary abatement, temporary modification on motion. As far as I know, according to all the case law that's out there, the legal analysis still remains the same, and the procedure still remains the same. It would have to be done on a petition. Now, I think a well-pled petition may entitle your client to temporary relief, but it still has to be done on petition, as far as I know. Again, if you can find authority that says otherwise, I'm happy to hear it, but that is something I've been seeing emerging more so as we go on, and there's really no end date in sight. And I know a lot of you have clients that may be furloughed or out of work, and it's tough for everybody right now, but the legal analysis still stays the same. The other issue I've been seeing emerging has been for temporary abatements of support. And I've seen, I don't hear the alimony portion, but I've seen motions covering both. And I do want to kind of double down on what GM Szorosy said earlier about findings. How important the ability for us to make findings is, especially now. I think you're going to see a rash of, and may not necessarily be in Broward, but in other places perhaps, things that are granted under the umbrella of the COVID crisis that aren't necessarily supported by findings that are going to be reversed. I think you're going to see a lot of that. And for example, a temporary abatement of support. I would need to make a finding that your client has absolutely zero ability to pay, has no eligibility for maybe unemployment, which they have expanded eligibility for right now, or other forms of income or anything. So again, it's not to say it's not possible, but I do want to kind of really hammer in the ability for us to make findings. It's really important.
Yeah, I think that is important. One of the other things I wanted to bring up, it's sort of a tip. Just as you would prep your client for a hearing in the courtroom, it's important to also prep them regarding the hearing being conducted via Zoom, letting them know that they need to find a place in their home to sit where they can listen and pay attention. And I think it's helpful to remind them that when a question is asked of them, that they pause prior to answering so that it gives the other side an opportunity to object. Pausing probably is going to be a little more than if we were in the courtroom because sometimes there is a delay. Also sending them ahead of time the documents that you're hoping to admit into evidence so that when you say to them, are you looking at your financial affidavit, they don't have to scurry around to find it. So just as you're uploading them to CMS, if you send them to your client, that would be also very helpful and have things just move along a little smoother, I think.
And I feel like I'm the comic side, I had a litigant eating, and I had to ask them to stop, or just ask them when that was going to stop. And then I also had, and remember, kids cannot be in these hearings. So I had a case and the child came up to the dad. It wasn't a child of this relationship, but anytime a child is in a hearing, you need to have permission from the court. So the child can't keep coming in and coming out during any hearings. And that was someone with a lawyer. I don't think that they had gone over that, but you may want to if there's little kids with your clients. You may just want to let them know that.
Okay, and I want to circle back to something that Magistrate Matalon said regarding familiarizing your clients with the documents. And this is really part of the push to start moving more complicated cases, more complex cases with more documents forward. Right now, there's been I think, a general trend throughout the bench at this point to kind of hold off on those cases because typically we're all used to coming to court, passing those documents around. A lot of times, some of those documents you may not even see till the day. I know a lot of times your clients may not provide it to you till that day, and we're all used to that. And it's not necessarily an ideal world, but that's the way things work. Going forward, I think we're going to have to all make a big effort to stop doing that. I think Zoom in some form is here to stay. I think even when the courthouse does reopen, I think you're going to see Zoom being used for certain types of hearings. And I think I don't necessarily know that the courthouse is going to reopen fully in June. There may be a phase reopening. I don't know. I don't have any insider knowledge. I don't know what it's going to look like, but I don't think when we do reopen, it's going to be business as usual. So I would, get used to Zoom or Zooming, but B, I would get used to the idea of familiarizing your clients with it, and also making a more upfront effort on the front end of your cases to get all your documents together, have everything done in advance, make sure you send them to opposing counsel, or file them. You can upload them onto CMS, make sure the judge or the magistrate or myself has them in advance. Everything is going to have to be done on the front end. It's going to be a lot more work in the beginning, but it will ensure, I think, that more complex cases can move forward. And given the fact that the future is a little uncertain at this point, and we may be resuming regular in June, we may not be, I think that is a good idea, especially if your clients want to have hearings. I think that's the only way at this point. And on that issue, I also want to impress upon you the importance of filing those notices of designation of email. Those are very important. If you've not done so on your cases, make sure you do those. Also, if you have a case with a self-represented litigant on the other side, something you may want to do is reach out to them and talk to them about possibly registering for the portal. Now, you can make sure that they know you're not giving them legal advice, which you're not supposed to be doing, but you may want to talk to them about possibly registering for the portal, because it can move your cases along faster, and it's a big help to all of us, because a lot of what we see is really at this point documents that are submitted to the portal or are emailed to our offices. Things that are sent in snail mail, I don't know when we're going to see those.
Yeah.
So thank you guys for being here. Apologize for my lateness. I was in a Zoom hearing. Fun. So thank you guys all for coming. I see we have over 211 people on here to hear from the magistrates and lots of questions. So let's get started. The first question comes from Ms. Pino. Are pickup orders being entered at this time, and how are those being addressed?
You would have to ask the judges for that. We don't have the authority to sign an order. So pickup orders always have to go to a judge. I know that many times people are asking for orders of referral on those. I'm glad that's a great question, because those need to go to the judge and they need to be set with the judge.
As far as you know, do you know if the judges are addressing those? Is there, because generally with pickup orders, they have to go into the courthouse, and that's prevented at this point. So to the best of your knowledge, for any of you, do you know if that's being handled or how that's being handled at this time?
I don't believe they are, but I wouldn't hold us to that.
We'll save that for our judge.
Please call, if you have a pickup order and that you need to have, please, first of all, make sure that you've looked at the administrative order on parenting and domestic relations case. It's Administrative Order 2020-30-temp, and it talks about some of the things about parenting and the repercussions. There's some makeup time, there's some video chatting. Everyone needs to be very familiar with that. And that might be an answer to, if you can't, it may keep you from having to do a pickup order.
Now, one of the questions I've gotten repeatedly right now is, I guess to you, Hearing Officer Tannenbaum, and to also GM Szorosy and Matalon, as in your capacity dealing with DOR. DOR is closed right now. So 2 questions I'm going to roll into one.
Okay.
How are we dealing with DOR as witnesses for hearings, for child support hearings? And also, if DOR is closed, how are we dealing with serving DOR at this point?
Okay. before I answer that question, I got clarification from Judge Bonastock on the issue of the pickup orders. She said they are being entered, but it would most likely need to be something that warrants an emergency hearing at this point, but they are being entered. Okay, regarding Department of Revenue, the Department of Revenue representatives are present for all the hearings that I've been doing. So they have been on the Zoom calls, just like they would be there in person. If you needed to subpoena someone as a witness, I guess it would go through the same process at this point, and they would appear by Zoom. As far as serving them, you are correct in that their local offices are closed, but they are accepting service at the agency headquarters in Tallahassee. So it will take a little bit longer, but that is right now the designated office for service.
Anything you guys want to add, here, Magistrate Szorosy or Matalon?
No, most of
No,
the
not
hearings with Department of Revenue go before Mr. Tannenbaum. And if you do have DOR on your case, you should be contacting those entities before you set it with us, even if the hearing officer referral, which is not even required, but if the hearing officer referral has our name but DOR is on it, please get with their assistance, because that might short circuit having it set in the wrong place.
Next question is, this is one that's always a big one. How are you guys doing evidence? I know that we talked about it with the binders. You talked a little bit about the CMS system that is now very heavily being relied on. Can each of you I know you have procedures up, and so can you just give a general information on how parties are to utilize CMS at this point and how you're utilizing them in your hearings? And the second part to the question is how you're handling evidence that is not stipulated to at this point. Is that also being uploaded to CMS?
Well, I'm asking that the evidence be uploaded to CMS. I do not look at any of the documents prior to the hearing. Obviously, I review whatever motion has been set or the other pleadings, the petition, but any documents that have been uploaded to CMS that may be evidence, I don't review them. Once we're in the hearing, if they're admitted into evidence, at that point, I will pull them up on my other screen and review them. The other part of the process is that once the hearing is over, if there are documents that have been successfully admitted into evidence, it is my understanding that once the courthouse reopens, that the attorney is responsible for sending them into us so that we may file them with the clerk's office, fill out the exhibit sheet that we're required to do with the clerk's office and file those documents. But so far it's been, I think it's been going pretty well. I'm not sure about GM Szorosy or Hearing Officer Tannenbaum.
Matt?
Well, my division at this point is trying to fine tune how we're going to handle that. We've been lucky enough, my division, that the volume of cases we have that mostly only require testimonial evidence is quite large. So we've focused on that at this point, especially when the closure in the beginning looked to be only for 2 weeks or so. But we are going to institute probably some procedures on how to accomplish that. Again, relying on CMS and a lot of advanced preparation from everybody to accomplish these things.
I did a trial the beginning of the week, and there were probably uploaded to CMS 50 different pieces of evidence and composites, and we were trudging through it. I mean, the case ended in a settlement after lunch, but we were fine. We were doing that. I had another case where there was evidence submitted, uploaded to CMS and done. And I just want everyone to know that if you go to CMS and you go to the help, across the, I'm just trying to see, I'm on it right now, from CMS all the way across to help, there is the user manual, and there are different tutorials that will help you if you're having trouble uploading things, and there's a workbench, and a lot of how-tos. And that's where the how to register for the first time, that's where you may send those opposing parties, if they're pro se, or opposing parties that are not from here, an Orlando lawyer or something along those lines. So that's a good reference point.
So I want to shout out real quickly Magistrate Lucy Ramos Miller, who's also on the call. She's hiding back there. Maybe we can get her to come on as well. Thank you so much for coming on. She wanted to just make sure that we remind the attorneys that pursuant to Judge Tuter's order, not wanting to have a hearing by Zoom is not an objectionable objection to a Zoom. It's not a good objection to the Zoom hearing. As of right now, those hearings are going to continue with that, regardless of the objection, unless there is something that the parties can agree on and provide the court in order to take more time or something to get the case ready. But as in general, the objections to having a hearing by Zoom is not something that's going to be granted. So in discussing the Zoom hearings, we talked about this before. What are you guys doing to ensure the quote unquote sanctity of the hearing, to make sure that people aren't there giving, people answers, or aren't, there are not others in the room assisting witnesses with their testimony? How are you guys handling that?
Annette, you want to take this one?
I mean, I've been asking if it's that I had a divorce today, and the two parents, the two litigants, were together. It was a dissolution of marriage, and I found that odd at first because, of course, I don't know who they are, but they both showed me their driver's licenses, and they lived down the street from each other, so I didn't think someone was posing as someone else, and they had an agreement, so it seemed logical, even though it seemed odd that they were in the same place. And they're, of course, sheltering with the same child, so they're all cross-contaminating each other if there is any thing going on. So with that said, I've done that. But I did see today that the civil bar came out with a webinar that's about what you do if there are off-camera, prompts being done, or if you believe there's off-camera prompts. I can tell you, in my hearings, I tell everyone I am looking off to the right because I have a separate monitor, not just looking off into space. I have a separate monitor that I'm looking. If I'm looking down, I'm writing. So it might just be that if your witness is going to be looking at something, that you absolutely make sure their face is in there, and that each of you have your client say, there's no one else in the room that I'm in. And the only documents that I have are the ones that have been, I think logically for our cases, I think we can figure that out. But if GM Matalon has something else, that would be helpful to us too,
I think I've heard, Kimmy, maybe you told us this earlier, perhaps just scanning the room, having them scan the room with the camera to show that there's no one else in the room with them, showing us perhaps what's on their screen to make sure that the witness doesn't have notes up on their screen, just as, they can't take notes on the stand. But I think we're trying to get creative, and as we go along, we're sort of figuring things out. I had a witness that kept looking at the screen throughout their testimony. They happened to be trying to shop online, but figured that out after. So I think we're just learning as we go.
Right, and I agree, and I agree with both those statements, and I think it's something we'll have to be creative. I think there's going to have to be a judgment call on our parts for a lot of these, and I know a lot of the other circuits that were slower to adopt the virtual platform, specifically I think Dade and Palm Beach may have been a little bit behind us, large in part for concerns of fraud upon court. I don't think at this point we are in a position to have any choice in the matter. In order to keep the wheels of justice turning, this is something we have to do. but you know, there is relief available to you if you find something like that has been done. So take comfort in that.
Are the courts, the magistrates using the recording, electronic recording from the courts in your hearings? Oh, sorry, wait 1 second. Braulio?
One sec. So you wanted to allow Magistrate Lucy Miller on, Ramos?
Yeah.
She's got to share her camera for us to be able to do that, or we could unmute her so she could speak. But we're going to need her to, if you wanted to come on her choice.
Okay.
So
If you want to be seen, Magistrate.
Miller.
all right, I will unmute her and she could decide.
Okay, thank you. So I guess people want to clarify if you're using the court electronic court reporting for your hearings, or since you're working from home, or is there a Zoom recording, or should we be using court reporters?
Must. It's a must. And you'll see the recording in the top corner, the little cloud with a red dot. We must. Just like moving under scraping tonight and putting it onto the, I don't know what scraping it means, but they're putting it onto the court reporting system.
Right, and everything through Zoom is being recorded to a cloud server, and only court reporting for the circuit has access to the cloud server. So I myself could not even go in and access a recording. If I needed to review it, they would have to send me an encrypted file. And if you wanted a copy of the recording, either by CD or transcript, you would go through the same process that you went through before. You would call court reporting, you would order it, they would transcribe it. It's the same process, they're just pulling it from a different file folder.
So just remember, if you expect us to, say there's a hearing that took place over a couple days, 2 different time frames, because this is going further, we can't listen to what happened the first time like we could when we were in the courthouse. You know, we can listen to it on fast forward, you know, if we need to remember, or we made certain, you know, comments at the end that we know where everything was. And if you had a hearing before and we're doing the continuation now, remember, we don't have the paperwork, so it might be incumbent on both of the attorneys to get together if you're doing a continuation, as I was the other day, to agree on who comes next and what's next. Okay.
The other thing I want to remind people, Kimmy, just really quick is, quickly is, if your clients are going to testify and it's that kind of hearing, I need to see them on camera. I'm not sure what GM Szorosy's policy is on this, or hearing officer Tannenbaum, but I need to see them to swear them in. So it would take less time if you let them know that before the hearing, so that they're prepared to either turn on their video or to have downloaded it, or whatever it is that they need to do. But I need to see them in order to swear them in.
I think that's the only way, according to everything. I think that everything that's been written, all of the AOs, all of the things from the Florida Supreme Court, we have to see the person. And it can't be frozen. You know, some people get on and they freeze. That's not, you know, we have to have real-time swearing in.
And don't assume that your clients know that, because they don't. That's one of those conversations you do have to have ahead of time.
Okay. So just to clarify, if the party is not appearing by the video portion, they have to have a notary to swear them in. So that's
Yes.
clear.
Yes.
Yes.
So the next question is, how are you addressing hearings, Mr. Tannenbaum, hearing officer Tannenbaum? How are you addressing hearings in your division at this time regarding child support modifications or child support abatements, and what's the quickest way to get you those so that you'd be able to address those? I'm assuming there's already a hearing, a referral to the hearing officer from this question. So it's directed to you. How are you addressing setting those hearings?
Okay, so we don't require referrals per the administrative order, but we do have them well. At this point, issues of abatement we'll hear now, largely because they're mostly legal argument. Issues of modification at this point, we have started setting them in June. I think we do need to do a few trial runs in my division. Because we have so many parties involved, we have the AG's office, we have DOR, we have both parties, and then often we have private counsel, possibly for one or both parents. We're going to have to start looking into doing trial runs for those, which is why we had set them for June, because we thought the courthouse was going to be open. And again, it may or may not be, I don't know, but it's something we're going to have to start looking at, because I cannot delay those hearings any longer than we already have. I mean, 1 month I thought was a lot to begin with, but I thought we could, get over that. But now that it looks like it's longer than a month, we're going to really have to look into those. But again, it's a little bit more difficult for my division because I have so many people involved, not all of whom have the same technological capabilities in order to view all the documents, which is why I'm really impressing upon people the importance of the upfront work you're going to have to do so that we can accomplish these. And I want to have these hearings done. I want to move everyone's cases through, but I think it's going to take a lot of work. If the issue is just abatement, that's something that we can get on the calendar immediately. And all you have to do is call my assistant. She is working remotely, like mostly everyone's JAs, but she will usually return your phone call within 20 minutes, and she will set it for a hearing. I did want to just touch upon the last question regarding the notaries. For a lot of my cases where it's just issues of contempt or driver's licenses, I'm not requiring notaries. I do have a lot of available to me because of the Department of Revenue's involvement, a lot of other indices of identity that we can talk about that only they would know. So sometimes we do take those instead, just because notaries generally are not available right now. And a lot of my cases have individuals who don't have smartphones or don't have steady broadband or Wi-Fi in order to connect by video. And something like their driver's license, especially given the current crisis and atmosphere, it's really important. And I know Judge Tuter himself has actually put a lot of importance on issues like driver's license reinstatements, and in fact has been holding those one-day net workshops, those kind of forgiveness things where people can come in and make a deal and get their driver's license. So that's something we're trying to do to help alleviate a lot of the stress. But again, that's something I think specific to my division, just because I have those additional things available to me. I don't know how it affects everyone else, but as far as the other issues, we are scheduling modifications for June right now, and abatements we can do earlier than that.
What about you, Magistrate Matalon or Szorosy? How are you guys handling, I guess, the abatement and modification motions as to do with the, I know you touched on it, this might have been someone who came in later, so if you could just briefly again explain how you're doing that.
Sure. I'm setting them as quickly as I can, especially those types of cases. So we've sort of rearranged our day a little bit in my division. We're going longer with hearings into the day. I'm not suggesting past 5 o'clock or anything, but for example, if I never set a hearing after 3:30 before this, for example, I am setting hearings to go longer and doing reports in the evenings or on weekends to give those types of motions an opportunity to be heard relatively quickly, as quickly as I can. So that's what we're doing with that. The one tip that I forgot to mention earlier is that when you're doing your notices of hearings now, folks, you have to include the Zoom instructions, okay?
Oh yes, that's actually something I wrote down to talk
That's
about.
one of the questions.
People are coming to the courthouse. It confuses people. Some people don't really know what's going on, so you need to include the Zoom instructions, okay?
So
And
how
I
do you,
agree, and even for hearings from June 1 forward, you can put on there, if the courthouse is open, it's going to be here, and if it is not, it's going to be conducted by Zoom. You can even ask the, call, put something on there, contact the judicial assistant or the assistant, in order to verify where the hearing will be held.
Right, and all the 17th Circuit has up on their webpage the full Zoom directory, so you can easily get we have a permanent link, so the link does not change, and the meeting ID does not change, so you can comfortably put into your notices of hearing with the caveats of whether or not the courthouse is open. You can put those Zoom instructions in there, knowing that they won't change.
So that was one of the questions. How, what's the necessary language required for the Zoom notification? So the general answer is to go to the website, get the link, and make sure that that is part of the notice as well, including the general. Or are you saying don't even put the general information, or which one is it?
Yes.
My
So
division, we're doing both. We're putting the general and saying, but if the courthouse remains closed due to COVID-19, your hearing will proceed via Zoom, and then it indicates the Zoom instructions.
Can you all hear me?
Yeah.
Yes.
Okay, I just wanted to interject really quickly here for a second, because I know specifically in my division, my assistant is readily willing and able to send out a template of sorts for the notices of hearing if there are any questions, so that, you know, if you're not clear on going to the procedures page, if you still have questions, she has no problem sending you a template of the verbiage to use in your notices so that you can easily just cut and paste or copy and paste.
Thank you so much for joining us, Magistrate Ramos Miller. Can you just, since you're on the phone now, give us a little update about your division and anything you want practitioners to know?
I think that the 4 family GMs are pretty much in line with what we're doing. We're trying to maintain as much uniformity as possible to make it easier for everyone. So I think that for the most part, we're all pretty much doing the same thing. So I don't think there's anything different that I'm doing that the others have not spoken on yet. I think, you know, the only difference for me has been that most of the evidentiary hearings that I've had thus far, there's either at least one pro se on the case. So we have not been able to use the supporting documents via CMS as much. What we've been doing for evidentiary hearings mostly is uploading those documents to the division email, and then just before the hearing, my assistant will send me, you know, one email with all of the documents that were sent to the division email so that I can easily access them. I have had very few trials where there have been 2 attorneys who've been able to utilize the CMS supporting docs function. So, but otherwise, we're all pretty much doing everything the same.
Can either any of you just kind of, we have a couple of non-Broward attorneys who keep asking, what is CMS?
And that's where you need to go to let me give the website. Hold on one second. CMS. Let me give the URL. CMS. Okay, so it's CMS. Oh, hold on. Dot 17th17th.flcourts.org. And that is where that is our case management system. And if you go onto the CMS system, that will absolutely, and go onto the website for the court, you will find all of the instructions for that, for the CMS system. Also, JIS, our information systems people, are available to help, but I would ask you first to do all the tutorials. They're self-explanatory. That's how we all learned how to use it. I think the people that you see right in front of you and GM Miller, we were all learning how to use it just more just as we were leaving, because we had a different system of receiving reports and signing them and all those things. That completely changed for us when we came home. The judges were already on that system, but we weren't. So it is absolutely a system that you can learn.
Yeah. And I'm sorry, I just want everyone to know, at least from my division, I'm not holding a hard and fast rule that they must be uploaded to CMS. If there is an attorney, for example, that we're hearing now that they don't know about CMS because they're from a different county, if you email them to my assistant or to the division email, I'm going to accept the documents that way as well. I'm not going to stop you from admitting your evidence because you didn't upload it to CMS and you sent them by email to Donna. So.
Right. And, you know, we will accommodate you. We will be creative. We will accommodate you. The CMS it's a great platform and it's an easy way to uniformly see things, but we will accommodate you. We will make it work.
The only thing that we ask in that vein is that you submit the documents in advance. Please don't send documents the day of, the night before the hearing. It makes it very difficult for us and the other parties who just don't have time to review them.
And I have trial notices that I'm still sending out. My trial notices always say to get an exhibit list and a witness list 14 days ahead of time. So I would assume that everyone has the things on there and in that time period. So you already have them all gathered. So I would assume that it would be easy to either put them into an email and send them to my division. My division is my assistant, and then or to CMS, because I think once you use it once, I do believe that everyone will understand how easy it is.
Yeah.
How user friendly it is. That's what I'll say.
How are you addressing interpreter trials? Or
So
using
I've had one by Zoom. I typically use the court interpreters. Once in a while, we have a private interpreter, especially if it's what they consider an exotic language. So anything that's really not Spanish or Creole at this point. It was a slog. It took a really, really long time. It was, you know, worked a lot like it would in person. There was some confusion sometimes with the interpreter as far as who was talking due to the connection issues. We got through it, but you know, if you have a case that requires an interpreter, give us really advanced notice, because I think we need to allot a lot more time for it than we typically would.
Yeah.
I agree. I agree. And remember, in our hearings, all the regular general magistrates, court interpreters are not designated. They don't pay for those to come to the hearings. You can't call and say, I need an interpreter. You need to make arrangements. If the other side is pro se, just because they're pro se, they still can't call up. Those interpreters for the court, sometimes they do us favors and sometimes they do judges favors. But for the most part, if you want your hearing to go forward, everyone needs to secure a court certified interpreter. That's what the rules call for. And they need to have their own Zoom. But I think that a lot of interpreters are up and running and doing this and ready to go. You can hire them.
There was a question about, a lot of thank yous, Magistrate, for doing this. Will you repeat the information about your evidence submission? I'm not sure if I missed that. So just to recap, with evidence, it's give yourself enough time to submit it to the court. We're submitting by CMS, but you'll also take it by, well, not by mail at this point, no. But you'll also take it to possibly, will you allow them to utilize the division email, but that might be too taxing on your JAs?
I allow them for my division to use the divisional email if for some reason they cannot use CMS. I would prefer if they use CMS because we already get so many emails and even more now than we did before. And I want to make sure that, you know, we see your email with your evidence. So I would prefer CMS, but I will take it by the divisional email if necessary. I don't want to speak on behalf of the other general magistrates, though.
I agree. I agree.
What about you, Magistrate Miller?
Same here. If you've got two attorneys and you're able to utilize CMS, it's a lot easier. But if for whatever reason, if there's a pro se on one side, or if one of the attorneys doesn't have access to CMS, we will accept it through the division email.
And I want to give you the opportunity to also address how you're doing evidence, and more so I've already asked Magistrate Szorosy and I guess Magistrate Matalon and Hearing Officer Tannenbaum has already chimed in on this, but want to give you the opportunity to chime in as well. With the evidence being submitted, how are you handling evidence that is not stipulated to? So right now we're all uploading everything. So you know, what about the evidence that has not necessarily come in to the court yet? And if, you know, if there are objections to that document, how are you handling those types of issues?
I handle my evidence the same way I did when we were in court, and that is I don't look at documents until they are admitted into evidence, either by stipulation of the parties or by ruling over objection. Once it's admitted, I will open it up and it's fair game. But until it is admitted and accepted as an evidence or piece of evidence, it will not be reviewed by me.
Yeah, just like in a regular trial. Just
and I will also add that part of my temporary division procedures includes verbiage that directs the parties that they are, during the trial, it is their responsibility to keep an accurate accounting of the exhibits so that they can include that list along with the hard documents as soon as the courthouse reopens.
And that's crucial if you want to take exceptions or if you want to take appeals. But we're not going to, I have to say, I chase people down for reports all the time. I'm not going to chase them down for the evidence. Just, that's the lawyer's responsibility. And I do, because I'm responsible for the report. But if someone doesn't think it's necessary to submit the evidence, even though I've told them to do so, please understand that when we get back, that would be last on our list to keep asking for. As an attorney, everybody has the responsibility, and that is how we've been told to do it. And we couldn't recreate that if we tried.
I see the bar president, Mr. Fletcher, is on the line. Hi, Michael. Do you want to say something?
Hello, everybody.
Hello.
Yeah, on behalf of the Broward Bar, the executive committee and the board, first of all, we'd like to thank you, magistrate judges in family law. I know we had the judges on in family law. Braulio Rosa and his remote staff right now are working hard to keep everybody informed. These type of seminars are unbelievably important, not only for people that are in Broward County, but people who practice in the courts around the state. You're giving some very, very helpful hints. I do want to tell you that a lot of people are looking at the PPP loans for their practices. I got an email from Jeff Ganacci at Iberia Bank. They are expecting to get money from the second wave of the PPP monies from the stimulus. So if you bank with them, you're a member of the bar, or you want to establish a quick relationship with them, I would reach out to Braulio, myself, or Jeff at Iberia Bank. It's an opportunity which really we're all hurting a little bit. We're all trying to practice. We're all trying to stay healthy and safe. But this is an opportunity to secure some monies to ensure the financial stability of your firms. So stay safe, stay healthy, and I will get my president's message out before the end of the month. Thank you.
Thanks for
Thank you,
coming.
Michael.
So we have about 4 more minutes before we wrap up. I know you guys have to get back to your hearings. So I will start with Magistrate Miller since she's on the phone. Do you have anything that you want to close with? We thank you so much for being here. I appreciate you coming on. I have a couple more questions. Before I let you do that, I'm sorry, someone just asked, how can, never mind. Can we just, I'll just have you do the closing statements. I'm sorry, Magistrate Miller. We'll start with you.
I don't have much more to add. I do want to thank the attorneys for being as cooperative as they have been, and especially for those who typically or traditionally weren't as technologically savvy. They've done a great job in trying to embrace the process that we are now having to utilize. So I do want to thank them for that. If I had one ask, it would be in those cases where you all have a pro se litigant on the other side. We are trying our best to get pro ses to file notices of designation so that we can push these cases forward, file notices of hearing, and file reports. But the only way we can do that with those pro se cases is if there is a notice of designation of email address filed. And I found it to be very helpful where counsel of record have volunteered to help pro se litigants to get them filed once they've, been signed and saved as a PDF. If they are able to get them to counsel, counsel has been willing to file them for the pro ses because the pro ses are struggling with the e-filing process. So if you all are able and willing to do that, it would really help us to help move your cases along, and we really would appreciate that.
And quick question before I have the rest of the hearing officer and magistrate. How are you guys setting hearings right now? I know, do attorneys have the ability to e-schedule for your divisions, or are we still relying mainly on coordinating with your judicial assistants?
Well, for me, you can e-schedule for motion calendar right now, which I believe is on Friday mornings. But for everything else, it's either emailing Donna or calling her. And again, also, we've had a bunch of attorneys just email us regarding questions about how things are being done. That's fine too. We're here to help you all and just to try to move things forward. So, but for us right now, it's calling Donna and emailing her.
Yep, everything's running through my assistant at this point.
Me too. I do have
Same
some,
here.
I think that I do have a child support calendar for quick child support hearings, but remember, if you have something that you need to upload and it's a half-an-hour hearing, then remember it needs to probably be uploaded, the guidelines, because I need the guidelines.
So parting words from you, Magistrate Szorosy, and then Matalon, and then we'll close with hiring officer Tannenbaum.
The only thing I want to say is remember the designations of the email, that is under the rules, of judicial, administration. So be careful about how you get them to do it. I know that we're trying to encourage them, but remember, if they're not there, if they haven't signed on, then when you are doing a notice of hearing, they have not given you permission to notice them by their email. And as you see the document, if you see the document, their address is at the top and the email is at the bottom. And many people, especially pro se litigants, are just filling that out as fast as they possibly can and missing that part. So do remember that, check all the rules for email service before you serve them by email, because they may not have to be at a hearing that you sent to them by email. Okay, thank you.
I just want to thank all of the attorneys for being patient with us as we work through this process and figure it out. Again, if you have additional questions that you can't find answers to on the divisional instructions for my division, please call Donna, please email her. We are getting back to you as quickly as possible.
Okay, and I just doubled down on those, thanking all the attorneys for being amazing through all this. There was, I think, a survey done in which it was indicated most courts around the country are currently operating at around 25% capacity. I had a phone call with Judge Fonistoff last night where we came to the conclusion that the 17th is actually operating at least 55% or above. So we're well ahead of the curve, and that would not be possible without the cooperation of the attorneys. So thank you, everybody.
I agree. Thank you so much.
So we had over 220 people log on today to hear from you guys. So we definitely want to thank you guys for your time. Thank you again, Magistrate Miller, Ramos Miller, for coming in, Magistrate Szorosy, Magistrate Matalon, and Hearing Officer Tannenbaum. So thank you guys also for tuning in. We're at the family section of the Broward Bar. We thank Braulio and Michael for always putting us first and giving us the ability to put these together for you guys. If there's anything else that you guys think you want to hear, please reach out to Braulio, reach out to Lauren. We're trying to do as many of these as possible to keep everyone up to date. And I'm going to turn it back to Braulio. Thank you guys again.